The case to have Miguna Miguna's deportation overturned and to have him freely returned to Kenya continued at the High Court today. It was the turn of the respondents in the case, who include amongst others the Director of Immigration, the Attorney General, the Interior CS Dr. Fred Matiang'i, who insists that the government did not break any law in ordering and carrying out his deportation, since he hasn't been a Kenyan citizen from the moment he acquired a Canadian passport.
Subsequent to the promulgation of the 2010 Constitution, the Director of Immigration has demonstrated the petitioner never applied to regain his Kenyan citizenship.
But in a rejoinder, Miguna's team told the court that while it is true he did hold a Canadian passport, his Kenyan citizenship remained valid by virtue of birth. The government has argued that under the new constitution, Miguna was required to have applied for a new passport to hold on to his citizenship. Miguna's team say that couldn't be further from the truth.
The applicant has a Kenyan identity card. He has a Kenyan identity card.
They also argue that a person's citizenship is premised more on the national identity card than the passport.
There are procedures to be followed before one can get a national identity card. And that goes without saying that you cannot get a Kenyan identity card without demonstrating that you're indeed a Kenyan citizen. My Lord, unless there is anything shown to the contrary, there is no evidence or material before this court to enable you to go behind the issuance of this national identity card, which in our submissions, for purpose of a determination of citizenship, a national identity card is the crucial document, not a passport. A passport, every citizen is entitled, but a national identity card is only issued to citizens.
The issue of validity of his citizenship aside, the government side also opposed the petition that seeks to have Miguna return to Kenya on grounds that he was engaged in activities that would have been harmful to the country. And they insist that there is evidence to back up their claims.
The Director of Immigration deposed that he received classified information from the National Intelligence Service on the post-election political activities of the petitioner, and that those activities are detrimental to national security. And pursuant to the provisions of the National Intelligence Service Act, he is willing to give classified information to this court in camera on how the activities of the petitioner were detrimental to national security. And it is a factor that we hope will weigh in the court's mind when considering the application that is before you.
Only on Thursday, a High Court delivered a verdict in a similar case, terming the deportation of Miguna Miguna as illegal as it was issued in contempt of the court orders. The judge will issue his ruling on this application on the 23rd of this month. Brenda Wanga, NTV.